in Australia, it's customary to give a welcome to country. So what we do is we recognize the Indigenous people on the lands in which we're presenting, and also the Indigenous lands on which you might be listening to this. And I want to think about in this moment, in this welcome to country, some of the wisdom and authority and structures that have been around for thousands of years. So in Australia, we have the world's longest continuous Indigenous culture. And I would say that the legal systems and structures in place there have a lot to teach us. And I'm sure you might want to reflect a little bit on the Indigenous cultures from the lands on which you live. So in that sense, where we go from the very local Indigenous people currently living on land, all the way up to the supranational and the structures that we have made in the last many hundreds of years, we end up with the very large UN. So that's the big topic I'll be dealing with. Definitely not, definitely a topic one can quickly address in 1 hour with maybe some 30 minutes for questions at the end. So if you don't understand me or are having technical difficulties, just let us know. And also, yeah, please feel free to let me know if I'm talking too quickly or you need some clarification, because Australians, we speak quick and we sometimes use a lot of slang, and I have an accent. So if you really are struggling, just let me know and I'll try and slow down. So let's kick off. Let me just move my slide. Okay, great. So the UN, as you might know, was created after the World War II, and is structured in part to resolve some of the failings of its predecessor, which was the League of Nations. So some of the important innovations from the UN that were not clear or were underdeveloped in the League of Nations is the complete outlawing of the use of force between states, except in self-defense, and also a system of collective security. So this is the UN Security Council having competence to act with military force. If you are on the meeting and you haven't muted, could you just check that you've muted yourself? Okay, great. So this system of collective security enables the UN to act with military force, as I was saying. So one of the documents we'll be spending a fair amount of time looking at this morning is the UN Charter. So I've just pulled out the main purpose effectively in Article 1.1. And that's to take effective measures, to take effective collective measures. So in part, I think about the UN's legal authority as being to attend to this goal. And the goal is not just to take collective measures, it's to take effective collective measures. And that's to prevent and remove threats to the peace and suppress acts of aggression or other breaches of the peace, and to bring about by peaceful means. So there's sort of two tracks here. There's the taking of the measures, and there's also the bringing about by peaceful means, things that will settle international disputes or situations to prevent a breach of the peace. That's just a general framing. The UN obviously has heaps of funds, programs, and agencies. We've got the World Food Program is in the news at the moment with respect to some of the aid and assistance they deliver all over the world. But we also have other agencies like UNRWA, for example, in Gaza. We have the Food and Agriculture Organization, some of these technical bodies which regulate all sorts of things. You'd be surprised if there is a topic out there. The UN probably has an agency that just deals with that. One time I was at the UN in New York and I discovered that there is a committee that the UN has that talks about how to name things. So it's just a bunch of geographers who are effectively the committee for deciding the names of places. And I suppose that is kind of important. So there is something out there. But the main 6 organs of the UN, these are prescribed under the Charter, are the Security Council, General Assembly, the International Court of Justice, the Economic and Social Council, the Secretariat, the big glass building in New York, and the Trusteeship Council, which is at this point in time pretty obsolete. The only 2 I'm going to talk about today are the Security Council and the General Assembly. And that is because they are the ones that have legal authority. They make international law state practice opinio juris. So that's where its legal authority is important. The International Court of Justice, of course, has legal authority as the court, but at the same time, it has the authority to interpret the law as it has been made, not necessarily creating legal authority of its own. So I'm going to avoid talking about the ICJ, although a super interesting topic. I feel like that one needs to have all of its own lecture. All right, so we're going to kick off with the Security Council because it's the most important lawmaking body in the UN. It's has, under Article 24 of the UN Charter, primary responsibility for the maintenance of international peace and security. And that primary responsibility is actually for not only the UN, but for other regional organizations. So it sits above most other international peace and security structures, but obviously collaborates closely with other peace and security councils, such as like the African Union. So just generally on the Security Council, I won't spend too much time on this slide, but feel free to take note of it. It is a summary of the UN Charter and what it prescribes to be the important procedural elements of the Security Council. So you have to have 15 members, 5 of them are the permanent 5, Russia, China, France, UK, and the USA. And then you have 10 elected members. And these are geographically distributed. So there's a certain number of seats for different UN geographic groups. At the moment, this can range from the UAE all the way through to, I have seen the Security Council with Albania, even St. Vincent and the Grenadines was on the Security Council a couple of years ago when I was there, which was really interesting because it's such a small country, but obviously has its own really specific needs and interpretations of international peace and security. And so it's a fascinating interplay of 10 very different countries with a lot of different needs and a lot of different opinions. And then the permanent 5, which we know their opinions pretty well at the moment because ultimately they have been there on the council for the 75 plus years that the council has been in existence. So they have a very strong influence, not only procedurally with the fact that they can veto resolutions, but also normatively. They have a very strong understanding of how it works and how to make Security Council resolutions. So touching a little bit on the veto, actually it's not really a veto per se in the Charter, but it is the requirement that a resolution have the concurring vote of the P5. So it is not necessarily that each of them is gifted with a power to veto, but rather the requirement that all of them must agree. An abstention by a P5 member has not actually in practice hindered the adoption of a decision. So an abstention does not count as a veto. So resolutions can pass even if all 5 of the P5 abstain from voting. So you can vote for, against, and abstain. So abstain is in the middle, it says nothing, but in some regards can say something. So that is how the voting system works. There are little sort of ticks at the moment where people are trying to understand how they can work within the current procedural background. So how do we get around the fact that the veto is being used for very critical activities of the UN and on massive breaches to international peace and security? And there is some argument that Article 52.3 of the UN Charter requires a party to the dispute to abstain and therefore not veto. But unfortunately, the rules after the Charter, so the Charter rules, which we have here, outside of the Charter, the rules are not particularly clear about how things work. So there are rules of procedure. They were written they've been written in a couple of iterations. The last one was adopted maybe, I think at this point in time, more than 20 years ago. And they're very light touch. If you go and have a look at the rules of procedure of the Security Council, it's actually a pretty small document. So what actually ends up happening is it's all about practice. So it says there's this kind of idea of, well, we haven't ever done it that way. So therefore, why do we need to do it? And that's just not how it works. And so while the Article 52.3 might say something, the Security Council hasn't been operating in that way. It's very hard to change that beast. Unfortunately, practice is kind of everything if the law is not specific. So that is kind of how I would talk about how the Security Council operates, and that is an important part of how it garners legal authority. I will move now on to the next slide. So here we're going to talk a lot about the actual legal authority of the Security Council, what it can and cannot do. There are 2 chapters that are relevant to the Security Council's activity. The first is Chapter 6 measures. We talk here about the Security Council's powers over dispute resolution, investigations of things that might be a breach to the peace or constitute a threat to the peace, how states can raise with the UN Security Council that there may be a threat to the peace arising, and the power of the UN Security Council to make recommendations as to that situation. However, I won't spend a lot of time on Chapter 6 because there's a lot of activities that can be accompanied or included in Chapter 6, but it's not considered to be necessarily binding Security Council activity. We'll talk a little bit more about that later when we talk about the resolutions. But the Chapter 6 measures encompass a lot of the Security Council's work, and you might not always see what they do. But for example, something like the International Investigative Mechanism for Myanmar, or a similar investigative mechanism which was constituted for Syria. These are all activities that the UN does under the investigation power. So they're not saying that there's a breach to the peace yet, but they note that there might be, or there could have been, and they will investigate that. And they will then therefore make recommendations to sort of resolve that dispute. To kind of conceptualize it as being kind of a before and a bit of a prevention angle. And then Chapter 7 is where kind of the rubber hits the road when it comes to the Security Council. I would conceptualize Chapter 7 as having 4 basic actions from the Security Council. One is they can declare a breach of the peace or a threat to the peace under Article 39. 2 is they can authorize non-forcible measures under Article 41. That's where you see economic sanctions and arms embargoes. 3, you can authorize use of armed force, including authorizing regional organizations to use armed force. And 4 is actions to restore the peace after the use of armed force. And that can be really creative. So we'll get to that later on. Okay, so on Article 39, the UN Security Council has to declare a breach of the peace or a threat to the peace in order to sort of act any further. So you'll see often that they do this all the time. In fact, since the Security Council has been established, they have very consistently declared a breach of the peace or a threat to the peace. So it's sort of a key part of their activities. One of the things I find really interesting about this article is that you have both a breach of the peace being a declaration and a threat to the peace. And a threat to the peace can be a lot broader. If you conceptualize it, like a breach of the peace is something has happened and that has breached peace. Whereas a threat, it might not have happened yet, but it could be arising. And that gives a longer temporal scope for states to act when it comes to the resolution. So, for example, this is a very seminal resolution, Resolution 1373, which happened just after 9/11. And you'll see here that the Security Council reaffirms that terrorism is an international threat to international peace and security. So they also note at the bottom of the resolution that it is acting under Chapter 7 of the Charter of the UN. So it's very clearly in the action authorization space. Sometimes the resolutions might not state what chapter they're acting under, and that makes it harder to determine whether or not they're binding, because Chapter 6, as I mentioned, not really binding, it's making recommendations, whereas Chapter 7, the UN Security Council is often deciding things which are binding. So it's very useful to have this acting under Chapter 7 of the Charter of the UN because you know exactly what we're talking about here. But sometimes it is often practiced that the UN Security Council will not state under what chapter or article it is operating, and that makes it a little bit more complicated to interpret. Then I will also show you an example of a time where a resolution is declaring a breach of the peace. You can also see somewhat a difference in how things have developed with the Security Council. The prior one was just the first page of a resolution from 2001. It goes on for pages after this. And this one that I've that I've got in front of you is just the whole resolution itself. So that's the start and the end. So resolutions have gotten bigger and bigger and makes it harder to interpret them sometimes because if you know anything about international law, which I'm sure you do, you have to interpret object, purpose, context, and that includes sort of the whole document itself. Whereas here, it's much easier when it's a lot more straightforward. So in 1950, the Security Council declared that the North Korean forces invading the Republic of Korea constituted a breach of the peace. You can see that there in the second line. And then it recommends down the bottom that members of the UN furnish assistance to the Republic of Korea as may be necessary to repel the armed attack and restore international peace and security in the area. So a lot of these declarations concern an internal conflict or a conflict which has the capacity to develop from an internal conflict into an international conflict. And some of the examples that you might want to use if you're looking for state practice or UN Security Council practice in this context is, for example, the Security Council has declared a breach to the peace or a threat to the peace to be, for example, migration from one country to another country. This happened in the case of Haiti in the 90s. So there was very bad civil strife, and so a lot of Haitians were departing, and the UN Security Council actually kind of targeted the migration as being a potential threat to the peace. Similarly, they have done declarations of a threat or breach to the peace with respect to civil wars that have the potential to destabilize the region around it. We saw this in particular, for example, with Liberia and Kosovo. And then we'll move on now to the Article 41. I won't spend too much time on this because it's not my area of expertise, but what it is a very important tool of the UN to, without authorizing military force or anything like that, to impose conditions and measures to try and bring peace about and to stop aggression. And they do this through arms embargoes, economic sanctions generally on a country, but also targeted sanctions on specific individuals, often leaders of countries. It has also been used to set up really interesting measures like compensation schemes or special fund programs. So for example, what I have up on the screen for you to look at is the resolution that authorized the Oil for Food program, which was a program by which Iraq could continue to sell petroleum for money, but that money was actually just targeted for food. So instead of just selling petrol for cash that was given to the reserve of Iraq, it was actually targeted so that the payment was food, and that was to be given to individuals. There was a fair amount of difficulties and issues with this particular scheme, but it was an interesting measure that was done under Article 41. You can see it doing that in operative paragraph number 1 here, authorizes states so that what they're actually doing in this resolution is authorizing, say, for example, Australia to purchase petrol from Iraq outside of the arms embargo that they had, sorry, not arms embargo, the sanctions that they had imposed, but that would remain lawful so long as it was under this scheme where it was for food. And you can see they also say that they're acting under Chapter 7 of the United Nations. So that's very helpful. Let me pull up another example. This is a very straightforward example. The Malian travel ban and sanctions regime, which was discontinued about a year ago now, but previously also acting under Chapter 7 of the UN Charter. And you can see here it says determining that the situation in Mali continues to constitute a threat to international peace and security in the region. So very clear, you can see exactly what they're doing here with Chapter 7. Travel ban decides a decision that for an initial period of 1 year from the date of adoption of the resolution, all member states shall take the necessary measures to prevent the entry into or through their territories of individuals designated by the Sanctions Committee. So again, how it's operating, it operates more about authorizing other member states to do activity on its behalf. That's always how the UN Security Council is operating. So that's just two quick examples in that regard. Now we'll get to the really interesting stuff. Well, I think it's all interesting, but this particular sort of stuff is what you would see more on the television and what you associate with the UN in a historic sense. So as I've kind of flagged with Article 41, in Article 42, it's similar with respect to the fact that the only way the UN can act really is to authorize member states to act on its behalf. And that is the case also with the use of force. So it's authorizing member states to use force on behalf of the UN. And this is because in the Charter, they envisaged from Article 43 onwards, if you open up your Charter and have a look, they imagined that the countries would gift the UN a military force that would just be of the control of the UN Security Council. That was probably a bit ambitious and it never happened. So they therefore went forward with a very kind of ad hoc system of agreements and things. Most of those agreements never really got off the ground. And so ultimately we ended up with this imperfect system, which we have now. So what is happening is that the UN Security Council is authorizing member states to take action. And when you are looking for the UN Security Council that is binding, which is these Chapter 7 decisions, you're looking for the language measures as may be necessary or all necessary means. That's an authorization. And you'll also often see the word authorization. These language is important because what it's saying, it's signaling the exact decision. It's not saying that it notes that it would be useful for member states to do something. It's authorizing member states to use all necessary means. And that includes military action. So as an example here, we've got a paragraph from a resolution from 1991 on Somalia. And you see here it says acting under, again, Chapter 7, very convenient. It authorizes member states to use all necessary means to establish a secure environment for humanitarian relief operations in Somalia. And the best part about, I guess, being an international lawyer is that you get to do the interpretation of what it means to establish a secure environment for humanitarian relief operations. And I think there's a lot of responsibility that comes with that. So 1990, we have this Somali resolution, but from 1990 onwards, we see the UN Security Council doing a lot of this. It's sort of unlike the declarations, which I said that they have been doing consistently. Article 42 authorizations have really only started in the 90s. Sort of the modern UN Security Council authorization. And it really started in part with the Iraq invasion of Kuwait in the 90s, which the UN Security Council authorized member states cooperating with the government of Kuwait to use military force. Again, authorizing member states to use military force. And then from the 90s onwards, it really started to ramp up with respect to Yugoslavia. So we'll have a look at some examples in this regard, just so you get a sense of what they're doing when they're doing Article 42. So here, for example, is a Bosnia and Herzegovina resolution. And this is a really interesting one because what it's doing is it's a military aircraft. It's stating that military aircraft violating a flight prohibition that the UN Security Council had established over Bosnia and Herzegovina were authorized to be shot down. So you can, that's a pretty extreme example because effectively, if you recall basic international law, the airspace above the territory of a state is sovereign territory of that state. And the UN is imposing a flight prohibition over that airspace, and then also authorizing states to shoot down planes that violate that prohibition. So it's a pretty extreme circumstance, but it's a really interesting one because it shows you that this kind of authorization to use force doesn't necessarily just mean send your troops to the destination which we tell you to. It can be quite substantial in that regard. And you'll see the language, all necessary measures to ensure compliance with the ban on flights referred to above. I obviously didn't extract for you the whole resolution. And you see that language of authorizes. Again, I also want to point out the phrasing at the second line that says acting nationally or through regional organizations or arrangements. We'll talk about this a little bit in a second, but what we're saying here is that the UN Security Council will organize, say, for example, the Australian Air Force to do something, but would also authorize a regional organization, say, for example, NATO, to do something. All right. Moving to the next slide, next example is we have, for example, here the use a decision. Again, look at that operative word at the top, decides that member states, again, acting nationally or through regional organizations, may take, and it's asking them to kind of do it in a way that's compliant with some recommendations of the Security Council, all necessary measures. That language is so important. Through the use of air power in and around the safe areas in the Republic of Bosnia and Herzegovina to support the UN mission in Bosnia and Herzegovina in the performance of its mandate. I find these ones really fascinating from an international legal perspective. In one sense, it's quite specific. You can only use measures using your air power in and around the safe area of this area to support a UN mission in performance of its mandate. So you could only do it if your action would comply with the mandate. The thing is, though, while being specific, it's also quite broad. All necessary measures gives a huge scope, but at the same time, it's limited to air power. So I suppose we're just talking about planes and military planes. But in and around the safe areas, when you're talking about a plane, around something can be hundreds of kilometers away, because a plane can take me in Canberra to Sydney. That's a drive in Australia of 6 hours. Here on a plane, it's only 40 minutes. So in and around becomes quite broad. It could take up one of the whole territories of a state, really. But it's to support the performance of a mandate. And when you look at a mandate can be really broad itself. So what is the mandate? Maybe the mandate is human rights. Maybe the mandate is counterterrorism. Maybe the mandate is supporting a democratic government. How do you connect the use of air power with one of those things? And what does the UN mission actually require? Just a reminder to put yourself on mute if possible, just so that everyone can hear me clearly. All right, my next example is on Article 42 is a really interesting one as well because it's a little less military in nature and it can be quite enduring and it has a civilian aspect as well. So this is the authorization here or the decision to deploy in Kosovo an international civil and security presence. So here you've got the security. Clearly that's going to be military activities. Civil could be people like me. I'm a bureaucrat. So that's a really interesting component. What are we doing with civil and security? But the UN Security Council can authorize that. It also authorizes at the bottom member states and relevant international organizations to establish that security presence with all necessary means to fulfill its responsibilities. So again, what is required in the responsibilities? What means would be required to fulfill that responsibilities? Being authorized by the council, but ultimately somewhat up to the discretion of member states on how they would do it. So I recognize we've been spending a lot of time looking at text, so I'm switching now to some photos, but I'll quickly explain what the photos are. So this one here is the NATO operation in the Adriatic Sea. They were effectively monitoring an arms embargo in the Adriatic Sea, and this is because the UN Security Council had authorized regional organizations to use armed force. So Article 53 of the Charter says that no enforcement action can be taken by other regional organizations without the authorization of the Security Council. So when I said at the start that the Security Council sits above is the primary responsibility for international peace and security, this is somewhat what I mean. They also need to authorize the use of force by regional arrangements. Regional arrangements can do their own arms embargoes. They can do their own sanctions. That's not a use of force, so they don't mind. But if they want to do military action, they do need to receive UN Security Council approval. So here's an example of that. For the NATO activity in the Adriatic Sea, the resolution was extremely clear. It said NATO is permitted to do this. But sometimes the UN Security Council is extremely opaque about what they can or cannot do. So, for example, with respect to NATO in Yugoslavia, the UN Security Council issued many resolutions about this topic, but for this resolution, they just recalled in Chapter 8 some of the relevant provisions about regional security arrangements, and that was interpreted to having been an authorization. And ultimately, at the end of the day, the UN Security Council isn't in the business of necessarily explicitly targeting and authorizing regional organizations. This is in part because the UN Security Council relies on them to do a lot of their work and doesn't necessarily want to be the arbiter of that. And they often have their own peace and security councils, like the African Union. And so, unfortunately, we have this disjuncture, I suppose, where the Charter requires the UN Security Council to authorize, but in practice, the authorization is very opaque. And all that is really required these days is a special mention of a regional organization as being is now interpreted as an authorization under Article 53. All right, coming to the end of the Security Council's powers, I will talk very briefly about some interesting things that they do to restore peace after the use of armed force, that fourth action that I spoke about earlier. So two really great examples is after Iraq invaded Kuwait, the UN Security Council authorized a boundary delimitation committee. You can see here that they what the boundary was being decided, and then proceeded to issue resolutions that said that the decisions of the Boundary Commission were final and binding. So that is one way that they can restore peace, quite an interesting one. The other is, as you would know, as international lawyers, ICTY and ICTR, the two criminal tribunals for Yugoslavia and Rwanda. So they established these international criminal trials in Arusha and in Bosnia, in former Yugoslavia. And these examples show that the Security Council has quite far-reaching powers to deal with situations after armed conflict, and they can use it how they kind of like. Obviously, with these kinds of subjects, in particular the criminal tribunals, you really need the agreement and cooperation of other member states, including the states on which the tribunals are established, because they have the criminals that you might want to try, for example. And you don't want to establish something that doesn't get agreed to. So say, for example, in the Boundary Commission example, you really do need that power of the Security Council because the decisions of it are binding on member states. So it helps to, instead of maybe having a long-term argument about whether or not that Boundary Commission is true or seen to be legally binding, they're trying to cut that out and just go direct to issuing that they will agree to the outcomes in that regard. So finishing up on the Security Council, let's touch briefly on what its legal authority is. I think I've mentioned it a couple of times, how it makes the resolutions, why it makes the resolutions. These are all important parts about it, what constitutes its legal authority. These are two kind of aspects. I think the first one is that it has primary responsibility. As I said, it sits above. In addition, Article 24 of the Charter states that the Security Council acts on behalf of member states. This is an underlooked part of the Charter. I don't think it's a golden or a crystal bullet for your difficult legal problems, but what I do think it does is it's talking about this conferral. The Security Council is making decisions on behalf of 193 member states, and it needs to kind of remember that most of the time. In particular, Article 2.5 also obliges all member states to give the UN every assistance in its actions taken in accordance with the UN Charter. And it also obliges states not to give assistance to states who are acting against the UN Charter. So say, for example, you might be assisting a state to get around an arms embargo. That would be in violation of Article 2.5. And importantly, and it's not on the, it is, thank goodness, I had a dream last night that I didn't include it. Article 25 says that UN members agree to carry out the decisions of the Security Council. So anything that is a decision, aka Chapter 7, is obliged, you're as a UN member state, you're obliged to carry out the decision. Importantly, I just also note the UN Security Council addresses resolutions to non-state entities. So, what's its legal authority to Al Qaeda or Hamas or anyone? And then it often delivers these resolutions and targets non-state actors. But this is based on the view that the UN Security Council has full jurisdiction, at least concerning the territory of all member states. And so while they might not pay attention to what the UN Security Council states, if they are looking for legitimacy and they're looking to take a seat at the Security Council, either because they are seceding or because they're trying to take over control of the government, they will probably want to pay attention because it gives them legitimacy. So, yes, the obligation is really under Article 2.5 that you have to take into and you have to accept and carry out decisions of the Security Council. The one thing I will say is the ICJ has rejected the view that Article 25 of the UN Charter applies only in regards to Chapter 7, and this was in the Southwest Africa Namibia Advisory Opinion. They stated that all resolutions of the UN Security Council could be considered binding, and ultimately what you have to do is look at the language of the resolution and to sort of analyze exact words and frames. This, however, is quite contentious because the Southwest Africa cases, as you would know, including the advisory opinion, had a lot of dissenting opinions. And so it's hard to state that the ICJ was very clear in this regard. And the UN Security Council doesn't really want to weigh in on this. They would like to keep it as it is, which is a bit of a mess, to be honest. But in practice, what has ended up happening over this time is that decisions of the UN Security Council outside of Chapter 7 are recommendations most of the time, and therefore they are not binding, but they must be considered. A Chapter 7 resolution is a decision, and therefore it is binding on member states. All right. I'll quickly touch on the UN General Assembly. This is my team from New York. There's this sign out the front of the GA that always is literally always there. I think it came a few years ago as like a hashtag kind of thing, and now it's always there. So this is a bit of a famous photo for people who work at the UN. The UN General Assembly, as you probably know, meets once a year in New York in the high level week, which is where all the leaders come, but it actually is operating kind of all year round in an annual cycle. So the GA, I won't go too deeply into this, but I think the legal authority from the GA definitely comes from the fact that all states are represented with one vote. So if you're looking for state practice and opinio juris, as you know, the Nicaragua case tells us that we can get that from General Assembly resolutions. You've got a lot of states all together making decisions on something, so you can get a good sense of what people or countries perceive the law or the standard as having be at the time. In particular, to pass a GA resolution, you need 2/3 majority. So you actually do need quite a few countries to be there and agreeing with you to pass. But unfortunately, it's members present and voting. So if you're not in the chair, you kind of don't count. It's not, it's quite difficult in that regard with respect to countries who are very small and under-resourced. They might not attend the meeting and they might not press go, yes, no, or abstain on a resolution. So present and voting is in part of the job is to actually go in and get people to turn up and to care about your issues. So it's like kind of like lobbying in that regard. The UN General Assembly can discuss questions on any matters within the scope of the Charter and the powers and functions of the UN organs. So massive amount. They are not able, though, to talk about a specific subject if the UN Security Council is exercising its powers on that situation. So here you get a bit of a, I guess, a rift where the Security Council will want to take responsibility for what it is enshrined to take responsibility for, which is international peace and security. And the General Assembly is therefore kind of barred from discussing it. But in practice, the GA talks about things that are very broad and general, and because it cares a lot more about human rights and development, it's easy to typify what the GA speaks about as being different to what the Security Council speaks about. So that's an easy way to sort of get out of that problem. All right, I'll give you a brief hit of what the General Assembly can discuss. And I mean, shameless of me, I'm sorry, but this is a photo of me delivering a statement at the UN General Assembly, my only time I ever stood at the podium. And my discussion on my speech was about the use of or the mining of diamonds that fund conflicts. So you will hear of this maybe being discussed. I don't know if it's maybe an English phrase, but something called blood diamonds. So they use the diamonds to pay off mercenaries or to fund weapons purchases. And like the mining of diamonds is extremely harmful and often done by children. So that was really cool. Massive moment, I think the peak of my life. But yeah, the UN General Assembly can discuss something as, very specific as diamond mining for conflicts all the way through to some of the biggest issues of our time, whether that's sea level rise or even fisheries. It can be quite broad. So that is why the GA is like probably the craziest place to listen to people speak, because you just have like 1 hour you're speaking about whales, and the second hour you're speaking about arms transfers to North Korea. So it can be pretty crazy in there. But effectively, they're able to speak about maintenance of international peace and security. So, again, we have that crossover with the Security Council. You can make recommendations to states, but again, it's only recommendations because the General Assembly doesn't have that decision-making power and authority with respect to situations. That's where the UN is meant to have its role, and that's why there's that deference between the two of them. And the General Assembly can recommend measures for a peaceful settlement of a dispute, especially if it's likely to impact all of the world, because it is the audience for all of the world. And it also can call it to the attention of the UN Security Council situation. So sometimes the UN Security Council doesn't want to consider something to be a situation that's going to endanger peace and security. Maybe it's because one of the P5 or one of the elected members is involved, and so they're trying to like not really talk about it. The UN GA can talk about it. Let me sort of briefly touch on what the legal authority is, therefore, of the GA. So I see it as three things. And this is just my idea. I didn't get this from anywhere, but I'm sure there's a lot of people that have very smarter, more cleverer ideas about what its legal authority may be. But this is, for my view, the simplest way. The one I think is that resolutions create state practice and opinio juris, as you say, or as I said, and they also are the archives of our shared history. If you want to look back and think about what we all as a community thought about a certain thing at a time, you can go and find a General Assembly resolution about that thing. I think that's really fascinating. Then, secondly, we're talking about norm creation and dispersion. So you have all of these committees. There's 6 committees in the UN. They talk about disarmament. They talk about economic, social, and cultural rights. They talk about human rights and non-discrimination. They also talk about the development of international law and creating treaties. You're getting everyone in one place and providing them with an avenue by which they can create norms amongst each other and socialize ideas. I cannot imagine the world without this forum. The other is peer pressure and accountability. You might recognize some of the people on the screen here. This is the Minister for Foreign Affairs of the Russian Federation last year, attending the UN General Assembly. And he has to talk to the rest of the member states, and he has to hear from them. It also gives him an opportunity to share what he thinks about things. And so it's extremely important. In particular, it's kind of crazy to me because in this world where we could just kind of turn off and decide that we don't care about what someone thinks about what we're doing and just not turn up, they still turn up. Countries that are recalcitrant still turn up. So this is Gaddafi. And Libya was very much not a country that was used to agreeing or doing what the UN had suggested. And he still turns up to the UN General Assembly at the high level week to share his opinion. In fact, this was this photo I got from a Guardian article that said like the top 20 craziest moments at the General Assembly. And Gaddafi effectively spoke for the longest time that nearly anyone has ever spoken at the podium. But it talks about how important it is. It's a level of accountability. They have to come, they have to hear, we have to hear them out. And that's so important to keep that happening. Otherwise, I cannot imagine what the world would look like. So just coming back briefly to the resolutions piece, people always ask, well, why can't the GA just pass a resolution if the Security Council is not going to pass a resolution? Unfortunately, the resolutions of the General Assembly are not binding. They can only make recommendations. And you see that in Articles 10 to 14 of the Charter. So they're not binding, but the ICJ has said before that, and this is also in the Southwest Africa case, all states concerned are under an obligation to at least consider their content. So we are under an obligation to consider what they've said. The ICJ has also stated that the UN General Assembly is not debarred or barred from adopting resolutions which make determinations or have operative design. So you see this a lot with like the GA resolutions that decide that the GA is going to consider an issue. So they might consider, like recently, the Summit of the Future. These are all decisions that the GA is making about its own operations. And the GA also decides on the UN's budget. So that's its legal authority in that regard. It also has a bit of a backup power, as I kind of mentioned before, about the interaction between the Security Council and the GA. At times when the Security Council has been totally unable to act, the General Assembly has been able to step in and do something. And the question here becomes, if the Security Council is really unable to act, and there are these mechanisms by which the General Assembly can act in its place, and you get enough state practice and opinio juris, do those resolutions become binding because they're deciding on behalf of an organ that cannot decide for itself? This is very contentious and not very well established because there's just not a lot of practice on it, but there's a fair amount of academic commentary. So in the 50s, during the Korean War, very quickly after this UN was created, they created the Uniting for Peace resolution in 1953. And that was a resolution which effectively gave the General Assembly the power to act as soon as the UN Security Council fails to act, when 9 member states of the Security Council agree. So you've got a majority in the Security Council, and someone's vetoed it. You get some powers through this resolution to the General Assembly to act. What that looks like is sort of unclear, but effectively the General Assembly can meet in an emergency special session and pass resolutions that make recommendations that might be maybe more binding. And so therefore these emergency special sessions are often more used. Like the Security Council members who did not like this resolution in the 50s pretty quickly started using it. So related to that, a more modern version is the veto initiative. This passed in 2022 when I was at the UN. Apart from amplifying the workload of people who worked there because now we had more meetings, it's an extremely important initiative. Effectively, the Security Council kept getting more vetoes despite escalating global crises, and that's because they have an interest somewhere in the dispute or in flow-on effects from the dispute. And what happens now is when there's a veto employed by the Security Council, the UN General Assembly must meet within 10 days to discuss the matter and pass a resolution on the matter. And so, it's really interesting because the Security Council members have to front up to the General Assembly and explain why they vetoed. And well, they actually don't have to, like it's not mandated that they must, but it's become a very quick practice that they will, and they'll go over and explain themselves. So since 2023, like just in 1 year, 8 resolutions and 1 amendment have been vetoed. So that's 9 vetoes That's pretty much kind of close to one a month or one every 6 weeks. That's a lot, actually. And it has had a very serious effect on the operations of the council. If you're curious, these are the countries that veto the most. This was made in 2022, so it probably has changed a little bit with respect sort of to the US and Russia in particular. China very early on decided that they were not going to veto. They weren't going to use their veto in a principled way. They didn't want to veto in situations of atrocities. So they are actually quite low. China used to veto quite often when it first, even though it's only at 16, like really early in the council, it would veto. But I think that that has gone away, especially when you know that Russia might veto. You kind of get to be like, I'll just abstain because someone else is going to veto. Same with the UK and the US. But yeah, it's really curious, right? Because it's definitely the Russians out in front, but at the same time, the US does it fairly regularly. And in 2022, you can imagine that in the last 2 years, they've definitely increased their vetoes with respect to the actions in the Middle East. So quickly, just touching on some other aspects of legal authority of the UN, and also just talking about this kind of problems of some of these bodies. We also should maybe mention some ideas for reform. So I would say the most useful for a problem question perspective document with respect to UN reform is the World Summit Outcome document. And this was a document that Kofi Annan had kind of thought about being a reform agenda for the UN. And this is his report, In Larger Freedom. Some amazing, great ideas in it. And some of these are still, on the wish list of the UN. And effectively, the World Summit Outcome document got all the leaders together to endorse it. And so you can consider a leadership endorsement of the World Summit Outcome document to potentially be state practice and opinio juris. In it is UN Security Council reform, prioritization of conflict prevention and peace building, not just responding to crises, responsibility to protect, that legal doctrine that was endorsed by consensus in the World Summit Outcome document. Really interesting. And also a great thing that I wish we'd done is the resurrection of the Trusteeship Council as a global environment chamber. That was Kofi Annan's kind of idea. I think that would have been so good. And like, if I think about it now, I only wish that we had done that. We maybe would not be in a situation like we are now with like the Conference of the Parties on the UN Framework Convention on Climate Change, which is helpful for sure, but definitely not the kind of level of permanence and importance that the environment deserves. And what we'll say with this is all of these reforms are ongoing. You hear about UN Security Council reform all the time. We only hope that it may happen one day, but it's very, very difficult to change these things. And I will say that they are ongoing because just last year, the Summit of the Future, or Pact for the Future, you might have heard of it, you might not, was a similar reform document that was endorsed by member states. And a lot of the content in there is some of the stuff that Kofi Annan was talking about many years ago. So it's still much a to-do list and a wish list. Summit of the Future spends a lot of time talking about the social contract and some of the changes and kind of that are required by international law and the UN to address really niche issues like climate change, to talk about digital issues, to talk about what we're going to do with migration and things like that with respect to maybe climate change, maybe other things. So it's a constant project. I would just end off with a couple of, I'll answer your questions and end off with some recommendations if you're interested in knowing more about the UN. These are two fabulous books, my favorite books. Sergio is by Samantha Power, who used to be the US rep to the UN and is current head of US aid, or used to be. I mean, well, she will be for a little bit longer until Trump administration, I suppose. She is a fantastic writer, and Sergio was one of the heads of the UN bodies, and he was probably likely to become Secretary General before he died in bombing in Baghdad. And this kind of biography speaks so much about how the UN works and operates, and is just a fantastic book and talks about the hopefulness that people have about the UN. And then the other is sort of a little bit less positive, but talks a lot about the failings of the UN and where this comes from. And I think the thing that sticks with me on this is that the UN is often criticized. Why can't it do this? Why can't it do that? But actually, the UN is the sum of its parts. And so it's a constituent organization made of Australia, made of Colombia, made of all of your member states. And it does what your governments tell it to do. And so it's the member states that empower it or constrain it.